Great. Thanks so much for having me. I'm sorry I can't be there in person with you all, but hopefully you all are seeing some slides. Eric's going to run them for me because he's told me that makes them a lot clearer for you. So apologies when you hear me say next slide. And if you can see me talking into my phone, that also is a bit awkward. It's because I want to make sure my audio is coming in as clear as possible for you. You know, we've been talking about this suit for years, and I'll give you all an opportunity to ask any questions you have about where things stand at the end. So some of this may be a repetition for those of you who have heard these presentations in the past, but I want to make sure we're all on the same page, and then I can update you on where things are now. So what's the essence of RCAF's checkoff litigation, this constitutional challenge to the checkoff? And the essence is what all of you know full well from having watched and paid the checkoff for decades now, which is that the checkoff is really a transfer of wealth from individual producers to major corporations. That the checkoff is being used not to advance the promotion of beef writ large, or particularly American beef. What it's being used is to endow companies who have no commitment to the American rancher to advertise their products as they see fit. And these are actual checkoff examples that you see up here in the slide. And these are all examples where, right, very clearly you know that the thing being promoted isn't the meat product or your product, but rather the company, Weber, Pepsi. What's coming across loud and clear on these ads, you may see the checkoff check, but what you're really seeing is that you are paying for these companies which have major advertising budgets to enrich themselves. And Eric, if you go to the next slide, please. So how do we challenge this from a legal perspective? And as many of you know, this has been a long road that has been fought many times. So what did we do that was different, and what are kind of the anchoring principles? Two principles are now well established in the law. The second one I personally disagree with, but we have to live with it because that's what the Supreme Court's told us we have to live with. So the first principle is that if you are being forced to pay for someone else's speech, that violates the First Amendment. It violates the First Amendment, in fact, in two ways. By being forced to give money to a private entity, you're being forced to associate with that entity, and that violates the freedom of association. And by being forced to pay for speech, that's the equivalent of you being forced to speak. Money, the Supreme Court has said, is equivalent to speech, and so if you're forced to pay for speech, you are being forced to speak, and so that violates your freedom of speech. And the Supreme Court looked at the checkoff and said, at the time in 2001, this was the mushroom checkoff, looked at the checkoff and said, there's just no reason to force producers to pay for this. There's no good governmental justification for this, to pay for private speech. And so we're going to say that the checkoff doesn't just implicate First Amendment rights, but it violates First Amendment rights. So the test in the First Amendment is, first, does the First Amendment apply? It does because of the freedom of speech and freedom of association interests. And then do you pass scrutiny? And which means the test to see whether you can still violate the First Amendment. And what the court said in the mushroom checkoff case, United Foods, was no. The checkoff fails all levels of scrutiny. So that's principle one. Principle two is that something called government speech is entirely exempt from the First Amendment. And this is the principle that I think, if the court were to revisit it today, probably wouldn't be the law. But nonetheless, in an opinion written by then Justice Scalia, what the court said is that when the government speaks, that the First Amendment won't apply at all. So we don't need to get to the question of whether it survives First Amendment scrutiny. The only question is it government speech? And the answer is yes, it's safe. And what they did was then in the beef checkoff case, they said, well, when we look at the beef board and beef committee, we're going to say they're engaged in government speech. They are still non-governmental entities. But because the government controlled the actions of those non-governmental entities so extensively, and the language here at the bottom is the key language, from beginning to end, they controlled the message. The court was going to say that those two entities were engaged in government speech. And so we never got to the question in United Foods about, does it violate the First Amendment? Yes. Does it fail scrutiny? Yes, because what they said was the checkoff, when it's government speech, is entirely exempt from the First Amendment. Next slide, please. What RKF did in this suit was it looked at the makeup of the checkoff and said there's a big gap in what the court analyzed. What the court analyzed was just the Beef Board and Beef Committee, the right-hand side of this chart. But in fact, what the court said in a footnote in Johans was that it assumed, for the sake of that decision, the qualified state beef councils, the councils where you actually turn over your money to, in Montana, in all the 43 of the 50 states in the nation have qualified state beef councils. It assumed that all the money going to those councils was voluntary. That was its language. We're going to assume that you only give money to the qualified state beef councils when it's completely voluntary. And from discussing with Bill, and obviously as you all well know, that's just not the case. And what this chart very clearly says is that what happens is you give your money over to the qualified state beef councils, they send 50 cents over to the board and committee to use for that government speech. But 50 cents stays with the councils, and they get to use it how they choose. And we said, well, that's a gap in the court's reasoning. Are those councils actually engaged in government speech? We don't think so. We think they're private entities engaging in private action, and therefore you are, again, being forced to pay for someone else's private speech, and that's violating your freedom of speech and association. And particularly when we began this case, we focused on Montana because that's where RKF invested a lot of time, and the Montana Council was really out of control and was paying for Wendy's advertisements at the time. And the next slide, please, Eric. And we won, right? That's the bottom line. We won. What the court said twice in the district court and then once in the Court of Appeals was the Montana Council was unconstitutionally using the checkoff, that the statutory and regulatory regime that controlled the Montana Council, and in fact controlled all the councils, was insufficient to turn private speech, into government speech. So when the councils took the money, they were still using it however they so chose. They were private entities. The government did not successfully regulate the councils to make the speech from beginning to end government speech. And so every time the councils put the money to their own use, which means that for decades, how they've been using the money is that they were using it in an unconstitutional way that violated your freedom of speech and your freedom of association. So what happened next? And Eric, next slide, please. So then we realized, well, if the government's going to rely on just these statutes and regulations that are universal for all the councils, and we can establish that those statutes and regulations are insufficient, we don't need to just focus on Montana. We can expand the case to challenge the use of all these purely private councils. So we focused on these states in addition, or these states total. This is the full list of states. Why these states and why not the others? The key is that some of the state councils have some relationship to the state government. And so to try to kind of focus the court's attention on the private speech and the fact that these are private entities using it for their own expression, we focused just on councils where they were wholly private. These are entities that are set up privately, they are privately incorporated, they select their own board of directors, they select their own staff, they determine how the money is going to be spent. And so we focus on these states for that reason, to not get into a fight about whether the state government involvement changed the question or anything like that, just to kind of really home in on this issue about whether the speech is private speech or government speech. And we expanded the case, and now we're involving all these states. And next slide, please. So the government at that point realized it's going to lose. It's going to lose, and all of these states are going to, the use of this money is going to be declared unconstitutional going forward in all of these states. Just like the courts already found that it was unconstitutional for the last 30 years. And in response to that, the government drafted these contracts with the state councils. What those contracts attempt to do is turn the state councils into something more akin to the beef board and beef committee. So what the government said is, going forward, you're going to have to show us all the advertisements you're going to produce. We're going to have to approve those advertisements before they go out. We're going to have to get notice of the meetings. You're going to have to turn over a bunch of documentation to us. Concerningly, for us and you, and I think lots of ranchers, these contracts can be voided at any time upon 30 days notice. But nonetheless, these contracts are now in place and change how the government interacts with all the councils on that list. And so the question then became in our case, was the contract sufficient? And was there anything more we could do to try to get greater accountability at the state beef councils? Next slide, please. What came out as we engaged in discovery, meaning we got documents from the state councils and from the government, is that these contracts have a very large loophole in them. So while the government now regulates whether the state council, how the state councils spend money, and it regulates and is allowed to attend their meeting, the state councils are still allowed to turn money over to other entities, and particularly to NCBA and the United States Meat Export Federation. Those are the two dominant entities that get the money, although others do as well. They're not the only private entities that get the money, but the Federation gets a lot of money, and USMEF gets a lot of money. And in fact, through that discovery, we were able to work with a journalist, Leah Douglas, to highlight this issue, and she calculated that just the Montana, Nebraska, Pennsylvania, and Texas councils in just 5 years turned over almost $20 million to USMEF and the Federation of Checkoff money. And we said, well, this is just the exact same thing all over again. You've tried to assert nominal control over the state beef councils, but now you're allowing the state councils to pass the money on to another private entity to engage with the money as it chose. And that's one of the things we really have been focusing on now in the case, is that those private entities, they're still getting the money to use it as they so choose. And I want to be very clear, this is entirely how they choose. So you probably can't read this text on this form, but what it says is the money is being given over either in unrestricted fashion or for certain quote-unquote prioritized projects, which merely say that the money should be used internationally or for research. It doesn't say anything else. And then the Federation and USMEF get to decide how they spend the money, and it must be spent on speech. So our view was, again, this was you being forced to pay for a private entity to engage in private speech, and therefore was violating your freedom of speech and freedom of association. And that is the issue we've really, again, homed in on in this next round of the litigation. Next slide, please. So this is where things came out was a little bit disappointing to us, where what the district court and the magistrate judge who was operating under him said was that we remain right about the state beef councils. It's only because of the MOUs, these contracts, that the state beef councils are still now engaged in government speech. If the MOUs were to disappear, then the state councils would be engaged in unconstitutional conduct. And therefore, the MOUs are essential to making the state council's use of the money constitutional. But the court found that the MOUs did make the state council's use of the money constitutional. So essentially what it said was, sure, for the last 30 years, you all have been turning money over unconstitutionally, but the government's rectified that problem through these contracts with the state councils. Next slide, please. When looking at the transfer of money to third parties, though, the court got a little bit odd in its analysis. What it said was, I don't want to get involved in that. And what's particularly surprising is the district court, excuse me, about the dog barking in the background, but what the district court said was, yeah, this is a shell game. They can essentially rig and that's the district court's language, shell game. They can essentially rig this so you can still be forced to pay for private speech by first turning money over to the state council and then the state council turning money over to a third party like the Federation or USMEF, but I'm not going to get involved in that. And they relied on this language from a decision from about 2 decades ago saying court's job is not to parse budget law. And that's not what that language means if you look at the case. What that language means is that if it's really unclear how the money is being spent, or the government has shown that it can regulate how the money is being spent, and we're not going to get into all the nuances of how the government's going to regulate that. But where the government is not regulating speech, where it specifically said that it's going to allow the state councils to turn money over to pay for private speech, then nothing allows the courts to dodge that. The court's role is to stop ongoing constitutional violations. And it has no ability to say, that's just too much for me to handle. If the government's not willing to abide by the Constitution, the very function of the courts is that they should be enforcing the law. And so the courts threw up their hand here and said, we're going to allow this shell game to continue, but that just seems totally inconsistent with what is their duty. The other thing we brought up to the court was that these MOUs can be voided. And we said, well, RCAF should get an order entitling it to enforce the original rule that the state councils are only constitutional if the MOUs are in place, if the MOUs never disappear. So in other words, sure, these contracts may make the program constitutional now, but we want to make sure that it remains constitutional, or the state councils use the money constitutional now, I should say, not the whole program. But we want to make sure that the state councils remain constitutional. And therefore, we need an enforceable court order that demands that they continue to abide by these MOUs, because the government's shown that it's willing to get out of those MOUs at the first opportunity. And again, oddly, the district court said no. What it said was it thought the government was going to rely on the district court's analysis, and it didn't need to enter in a specific order to enforce that analysis. It was just going to trust the government to do the right thing. Given that the government hadn't been doing the right thing for the last 30 years, that seems to be a little bit of an odd decision to make. So Eric, next slide, please. So where are we now? We are filing a brief to the Ninth Circuit, the court just below the Supreme Court, but above the Ninth Circuit, or excuse me, above the district court, which makes 2 arguments. First, that it's not, quote unquote, micromanaging to stop this shell game. That where there's a clear constitutional violation, that is where the money is going to fund private speech, like it's going to fund that of the Federation and USMEF, that needs to be enjoined. The court needs to say that's unlawful, because under the Supreme Court's holding in United Foods, that clearly violates the First Amendment. It's compelled speech and compelled association, and we know it violates all levels of scrutiny. And we know that these are private entities. This is the same scheme that the district court and the Ninth Circuit regarding the state beef council at the beginning of this case years ago said was unconstitutional. But it's now just done with the Federation and USMEF, and the court should not allow that to continue. And also that the court should issue an order saying that the MOUs have to remain in place in order for the state beef councils to operate consistent with the Constitution and use the money for themselves for the Constitution. So in other words, we're looking for an order that says the money can't go to the Federation or USMEF. And if it's going to stay at the state councils have to be operating exactly like the Beef Committee and Beef Board, and we need a court order saying that, because these MOUs were only entered into, these contracts were only entered into once the writing was on the wall that the government was going to lose. And when the government changes its practices only because it doesn't want to lose in court, it doesn't give anyone confidence that it's going to actually continue to abide by those practices. And so we need the court to step in and say that there has to be a mechanism to force the state councils to continue to abide by the Constitution when they use the money. Again, the money should not go to the Federation or USMEF at all. But when the councils use the money, we need a way to oversee that they are continuing to operate constitutionally, and RCAF should be empowered to do that, because we don't want to trust the government to continue to enforce the MOUs, but showed no interest in doing so. Those are the two arguments we're going to advance on the 31st. And when the government will get a response and we'll get a reply, the process before the Ninth Circuit, you should know, is extraordinarily slow. It's usually an 18-month to 2-year process. So my guess is we will be back here next year without a full answer to what will be the opinion on this decision, on this issue. But we're continuing to push this forward and continuing to try to find ways to empower RCAF and you all to hold the checkoff accountable and also make clear that the money should not be a corporate transfer of wealth. It should not be going to turn over and fund private entities who have no either government control or tie to the producer. But I guess the thing I do want to highlight here is that the suit's already done two things. One is it's made very clear that you were right at the beginning, that that it was a corrupt program, the money was not being properly spent, and in fact, it was violating your First Amendment right. And by doing that, it's laid the foundation to build legislative change. The ultimate way in which you are going to be able to reform the checkoff is getting people in the White House and getting people at USDA and getting legislative champions to say that the checkoff is a corrupt program that does not benefit those who are paying into it in the way it should, and therefore it needs to be stopped. And we saw dramatic momentum for that in the Democratic primaries. I, quite frankly, never thought that the checkoff would be a major issue in presidential politics in the way it was during the Iowa caucuses with Cory Booker and Elizabeth Warren coming out with clear statements about the checkoff's corrupt nature and articulating themselves as champions for trying to get rid of this program if they ever get in a position to do so in the legislature. And Booker in particular has been pushing legislative change. And so part of our goal with this lawsuit isn't just to establish your rights, but to continue the message that the checkoff is a corrupt program that is being used as a transfer of wealth from producers who need the money to corporations who are just trying to exploit others and enrich themselves. And if we keep on beating that drum, hopefully we will get enough legislative support so that we can begin to unwind the checkoff. And I think that's where hopefully the next 4 years can be spent, hopefully less, but the next administration can be used to push forward real legislative change. And I am really impressed with the amount of energy there is around this. The sponsors, so Booker, Warren, and Mike Lee has been the other big sponsor of this, really have expressed a great deal of support for these issues and have committed to pushing them forward. Eric, next slide, please. So I do want to take some time to answer any questions you have. That's a lot of legal jargon, and I know this is an issue that lots of you care very deeply about, but if I don't get to your question or something comes up later, this is how you can reach me in all of the various platforms. That actually is my work phone. A number up there, and so Bill has my cell phone, which is the best way to reach me nowadays. Our physical offices remain closed due to COVID and will be so for the rest of the year. So if you need me on my cell phone, Bill can certainly provide that to you. But I really appreciate the opportunity to work with all of you on this. We are looking forward to continuing working for you and really get this message out that producers should control their money, not corporations. Thanks, and I'll be willing to take your questions now.
Questions?
Yeah, Dave. This is David Frank from Kansas. I always got to say this. I'm the former president of the Kansas Beef Council because I own the Kansas Beef Council. But David, on the MOUs, did Montana was it in a escrow account, and did Montana Beef Council get their money back? And I got another question.
So, yeah, so this is an issue that came up in the press, and so thanks for your question and thanks for your help with the case. I should start off by saying that. So what came up in the press, and this was a bit confusing, was as we were doing discovery, a question came up about what was going on with the money that the Montana Beef Council was not supposed to be using. And the press reported that the Montana Beef Council was still being allowed to hold on to that. So just to take a big step back, when we first one, what the district court did was issue what's known as a preliminary injunction. So it's not a final order, but it's an initial order that says, this is unconstitutional, stop it. Or really, this is likely unconstitutional, stop it, and we'll come back and consider if you can convince me otherwise. And that was under the statutes and regulations, and the MOUs were an attempt to convince them otherwise. But while that preliminary injunction was in place, the Montana Beef Council was not supposed to be getting any of the checkoff money unless producers affirmatively said they wanted the Montana Beef Council to get money. And some producers did, and so for that money, they were fully entitled to use it. But for the rest, there was a rumor going around that the Montana Beef Council was still holding that money in a account, which would have been unlawful. We checked on that, and what we found out was from the government that what was actually happening was the money was being sent to the beef board, and the beef board was segregating that money. They were doing that, admittedly, for the hope that they could send it back to the Montana Beef Council, exactly like David asked. And, I think that is still their hope. I don't know whether they've done that now that the MOUs have been considered sufficient for the purposes of the First Amendment. But the money was actually going to the beef board, which was consistent with the court's order, and not going to the Montana Council. So during the course of the preliminary injunction, the money was going to the federal level, and that was getting it out of the Montana Beef Council's hands, which was consistent with what they were supposed to be doing. And we have a statement that I believe is in the public record, and I or Bill can send to anyone, which establishes this fact that that's how the money was being spent. So although the Montana Beef Council has represented at times incorrectly that it was allowed to hold on to the money, that in fact was false, that they sent it on to the federal level.
Okay, David, I got another one.
Sure.
On that memorandum of understanding, how can the USDA control, and in my state, the Kansas Livestock Association runs the Kansas Beef Council. It's a under division or whatever. But how can a USDA control a nonprofit organization like Kansas Livestock Association, where I have in the bylaws of the Kansas Beef Council, 12 times they got to get permission. The Beef Council got to get permission from the board of Kansas Livestock Association. So how can USDA control that when it's KLA is a nonprofit organization?
Yeah, so we made this argument to the district court, and the district court's view on this, which is supported by some Ninth Circuit law, is two different things. One is that the government does not need to appoint the individuals who are using the money in order for it to be government speech and exempt from the First Amendment. So we argued very strenuously that the government should be required to appoint those individuals. And both the magistrate and district court really ridiculed that argument. And so as a strategic matter, we are not focusing on that at the Ninth Circuit because we think it's going to be very hard to overcome the tone and presentation of the issue that the magistrate and district court made. But the other thing that's going on is what the magistrate and district court said is, and this is certainly true with the terms of the MOUs, and we've investigated this and worked to confirm it, that even though the government doesn't appoint all the members of the Kansas Council or really any of these private councils, Kansas is extreme in the amount of private control it has over the appointments, but it's not totally outside or inconsistent with the other councils. But even though the government doesn't appoint those individuals, they now need to send, before they issue an email or a flyer or engage in a program, they need to send all that, including the slides, things like that, to the federal government to review and edit those documents before they go out. And we, again, I'm happy to share them with you if you're interested. I can show you examples of that. My personal belief is that the government does not do a very good job in those edits, that they're pretty superficial, and that the government's concern isn't really on the content, but just on kind of checking the box of reviewing it. But I will tell you the government is in fact reviewing it and is checking the box at least. And what the court said is that the government's at least checking the box. That means the government's responsible. And this is why it comes back to the legislative effort that really needs to occur, that if the government's responsible then you need to hold them responsible at the ballot box or through lobbying or through letter writing or other political efforts, that the courts are not going to intervene if the government assumed responsibility for that speech. So another way of thinking about this is that every time the Kansas Beef Council or through vis-a-vis the Kansas Livestock Association issues something at this point, that is Sonny Perdue issuing something. And you need to hold Sonny Perdue accountable, and you need to get others to recognize that is Sonny Perdue signing off on that statement. And therefore, the administration and the Secretary of Agriculture needs to be held responsible. This is not, I'll be clear, the failure here has not been just for Perdue. The failure was Bill Sack. This has been a failure of multiple parties and multiple administrations, but that's how going forward we need to look at this, which is that if the speech issues from any of these councils, that's the government, and the government's responsible for that, and how can they justify the statements that these councils are making, and when they can't, because they won't be able to, then the time is to end the program. And I think that's where you get momentum behind the Booker, Lee, Warren legislation.
Yeah, I have a question as well. In regards to government speech, it's been established, it's been established that it is government speech. And I would say to that, what response have you gotten when you respond to the fact that if it's government speech, as it's been acknowledged, then Freedom of Information Act should also then apply? You can't have it both ways. So what has been the response? Because what I'm seeing when I ask that question is that it's a circular argument. They claim as if, well, it's, private, so therefore you can't have access to information. And then when you say, okay, well, if it's government speech, then I should have access because we should have access to government speech. So what do they say in response to that circular argument?
Well, so can I ask you a question back? Have you submitted FOIA requests since the decision in this case came down, the most recent one?
I know that there have been many, or that there have been organizations that have submitted FOIA. 2014, I believe, was the last one, but it's still ongoing. I can pass the microphone over here.
Well, so I do think, and this is a really important issue, the decision in this case from earlier this year, so that January was the final decision of the district court holding that these MOUs converted the state council speech into government speech. And I do think one of the real victories there is that we should be able to leverage that decision to demand that these activities are subject to FOIA. My understanding is lots of the FOIA battles have occurred before this, and that this is a new way in which you should be able to leverage FOIA and leverage this decision. Is I totally agree with you. It would be a circular argument to claim that these councils are in fact controlled by the federal government and the federal government is approving everything, but that they are not subject to FOIA. It may be that you have to FOIA USDA rather than the councils. I am not, to be clear, a FOIA expert, and that it is a very obtuse area of law. And so it may be that you are required to get the information from USDA, but because USDA is getting all these documents now, due to the MOUs and due to the changes that this litigation forced, that means that in USDA's mailboxes, there should be every single statement between the council's annual plans, email exchanges with the councils about what is and isn't appropriate. And USDA obviously is a member of the government, despite it at times trying to behave like it's not, and that should be subject to FOIA. So I do think that is a really excellent point, that this does open up a new, robust way to get public accountability of the state councils. We may have to go through some trial and error to do that, but that is something that should be able to really be pressed hard. And if it's not, if you're getting negative responses, please let me know so I can refer you to someone who is an expert in this who can try to litigate that issue, because that does seem to me to be an issue that is ripe for pressing.
David, this is Von Meyer. I'm also on the OCM, and to further your question there about the FOIA request, yes, OCM did file a FOIA request in 2013, and after long court battles back and forth, NCBA came in and wanted to be secondary in that, and we got it. We got nothing back on that other than a lot of blacked out pages. They claimed it was proprietary information and it should not be released. It would damage their contract work, and their ability to contract others would come in and take their position away from them. I believe, and I forget the numbers, but we got 900 and some pages finally back, and all but about 17 pages, I believe it was, were not blacked out, and those are pages you can find anywhere on a 990 form.
Yeah, I think the key here is to try again. So what our Kansas lawsuit has successfully done is change the legal landscape. Right, what it made clear was if the government's not controlling the expressions, it's unconstitutional. And the only way they can justify the statements is if the government's reviewing, approving, signing off, and that means there's public accountability for the statements. And so you should now be able to leverage this kind of panoply of decisions we've gotten thus far to say that even if the government withheld the documents before, that's no longer good law. But I do think that will require resubmitting the request. It will require to figure out the right target. It may be USDA, it may be the state councils, it may be some sub-branch of the USDA, but there should be a way to hold them to get more of that information. And particularly, I think it depends also on how you craft your request. So if you were to craft a request for things that they weren't yet releasing, maybe there's an argument that a contractor has a proprietary interest. Now, I don't think it's a very good argument, but it's an argument. But if what USDA is doing is signing off on something for it to be made public, and it's saying this is what the government wants to be made public, that argument should collapse. And the exchanges around that should collapse. It should be made public. And so there should be an effort underway to get that information. Again, this is not my personal area of expertise. I focus on the constitutional issues, but I do think this is a nice kind of heads we win, tails they lose situation where, yes, we got less than we wanted and that we didn't get an injunction against the state councils, but you should be able to take these decisions now and fight again to try to get that information.
Thank you. This is Vaughn again. Yes, it is still ongoing. It's basically in the stalling phase right now. That's how they're acting it.
Yeah, and I'm happy to talk to whoever to talk this through, Vaughn, if you want me to connect them. But and I'm always available. Thank you also for all your help in this litigation thus far.
Hello, Dave. This is Dave Wright. I really think we should keep fighting this idea of the MOU righting the wrongs of the past 30 years. Maybe we should ask for reparations then. And I'm being very facetious, but it seems like a good thing in the current political climate that we have. So my point I'm asking now is, if I understand you correctly, the idea is to make the beef councils, supposedly the beef councils are now under government speech and they have to respond to USDA, and the idea is to try to keep the Beef Council from spending money with the Federation and NCBA. Is that correct?
That's exactly correct. That the idea is to force the beef councils to use the money. If they're going to use the money, they have to use it themselves. And they have to engage in all these exchanges I was just talking to Vaughn about with the USDA so that there's a public record that we can access. And to stop them turning money over to the Federation and to USMEF or any other private third party. Those are the two examples I use because that's where most of the money goes. But the idea here is to stop the shell game that's going on, prevent any private third party from spending the money. As for what you refer to as reparations, what I will refer to as damages, there's been lots of discussion about that. I will tell you that it is a very complicated question because of a doctrine known as qualified immunity. So what you're essentially doing is trying to argue that the government and the actors, particularly at USDA were violating the Constitution, therefore you're owed money. And there's a problem with the doctrine of qualified immunity. Basically allows the government a get out of jail free card when it's a little bit unclear whether they were violating the Constitution. And it's a very deferential doctrine. It's been used in lots of, you probably have heard it come up recently in lots of these police violence cases, where it's been used as a way for pretty dramatic misconduct to nonetheless be kind of pushed out of the courts. The other problem you'll have is that even under our theory, the money would still be allowed to go to the beef board. So even under our theory, we've been focused on the state councils as saying this is out of control and that there needs to be another way in which the money is controlled. But under our theory, the money could constitutionally go to the beef board. So one of the things you'd hear back is, well, what's your real damage? And that's going to be hard to calculate. You need an expert to figure it out, and it could be very expensive. So while there has been lots of discussion about the kind of damages type suit, those are two hurdles that no one I've been able to talk to thus far have been able to overcome. And that's why it hasn't been brought.
Well, thank you, but I would like to follow up on this idea of the beef councils now having the money, which currently they have the money no matter how you cut it, but restricting the way they spend it. So I did 8 years on the Nebraska Beef Council. We had $10 million. Of course, we had to give $5 million to CBB. That left $5 million to spend in the state. So the argument becomes, and it's a valid argument whether you like it or not, is we can't spend all that money within the state. So therefore, we accept contracts from other people to help us spend the money. So we would accept contracts from, I don't know, whoever showed up, and presented a contract for some of the $5 million we had left. What I'm going to suggest to you that you may not care for, I'm going to suggest to you that the Federation will come to those beef councils and they will submit ARs to those beef councils to get that money. And not only that, most of those beef councils are tied to the NCBA state affiliate through staff and CEOs and addresses and buildings. And I guarantee you they will line up some kind of a contract saying that we spend the money, USDA, because what are we going to do with a staff of 5 people? How are we going to spend $5 million? And it only makes sense to spend that money, pool it in a group, and send it to New York.
So I fully hear the concern, and I brushed over this to try not to get lost in the weeds, but I can partially respond to that by detailing you a little bit more about the MOUs. So what the MOUs do is it's not just the state council speech that now needs to be approved by the government. If the state councils are directly contracting for speech that is under the state council's control, those two need to be turned over. Anything that's produced pursuant to those contracts need to be turned over to USDA before it goes out, and USDA needs to sign off on that. Again, I fully recognize USDA is a rubber stamp on this, but those should also be subject to FOIA, just like Vaughn and I discussed. What's distinct about the Federation and the USMEF expenditures is that those aren't contracts with the state councils to produce speech. When they send money to the Federation, there's no contract for them to produce something to send back to the state or for the state council to sign off on or anything like that. What they literally do is they say, and I'm sure you know this from your time on the council, take this money, tell us how you spent it after the fact. And that's different from a constitutional perspective than the contracts which need to be reviewed, signed off on, and approved by the state council and now the federal government. And I fully appreciate, and I am sorry I don't have more of a satisfactory answer for you than that the courts think that when it's signed off by the federal government, that is constitutional. That is what they've held. The bright spot, as I said, is that I do think that is now all subject to FOIA. And so while the money may be spent in less than desirable ways, you should be able to track it better. And more importantly, perhaps, you should be able to hold the federal government accountable. Because what the federal government in these MOUs has now said is that they're going to review how that contract money is spent. They're going to approve how that contract money is spent. And so when it's spent, it's an expression of what the government wants. And so if you think it's a waste and abuse, it's not just a waste and abuse of the state beef council, it's a waste and abuse of USDA. And therefore, you should be able to go to your congressperson, have them hold them accountable, and you should be able to kind of point to this and say, we need to vote on this issue. We need to rally on this issue from a political perspective. And I do think that's how you get long-term change.
Yeah, I'm standing up to ask this question in case I have to run. I've both been in the commodity side and I've been in the direct marketing side. And it was clear to me when I was purely in the direct marketing side, maybe the checkoff benefited me a little bit based on the beef ads. But I'm going to say it doesn't benefit livestock producers at all. So how the hell do we get rid of it?
You get rid of it. Sorry, please go ahead. I mean to cut you off.
Well, go ahead and give me the answer, because if we got rid of it, then we're not wasting time talking about how they waste our money.
You get rid of it with a statute that gets rid of it. So I know that RCAP is also working on a referendum, and the referendum is a conceivable way to get rid of it. I think it's a really good way to call attention to the fact that lots of people share your view, and therefore I think it's a really valuable political tool. I worry that USDA will manipulate the referendum, and so I worry about, and there's ways they can do that they've done in the past in terms of how they count votes, and so, and what areas how they kind of divide the areas that are voting and things like that. So I worry about that, and thus I think your best answer is to get legislation that gets rid of the checkoff. And I do think, as I said, that there are now people in Congress who have made this part of their platform. And that's the simplest way to do this, if you can roll it into another bill and get that bill to pass. But the referendum's another way, and that's, I think, how you get rid of it. And the effort that RCAP is doing on the referendum, even if not successful on its own, remains a very important part of that legislative effort. Although it can conceivably, despite my cynicism about USDA, also get rid of it on its own.